everything up. Everything up.
Good evening, everyone, and welcome to the Caucus Meeting of the Edward Cliff Borough Mayor and Council. Today is August 9, 2017, at 6:33 p.m. Madam Clerk, may I have a roll call, please?
Mayor Kranjak,
Here.
Councilperson Zaversa, E. Park, O. McMorrow, N. Park,
Here.
Wu,
Here.
Borough Attorney,
Present.
Superintendent of DPW,
Here.
Borough Administrator,
Here.
Borough Engineer,
Here.
Councilwoman O. Here. Mayor, everyone's present except Councilpersons Zaversa and E. Park.
Okay, thank you. Madam Clerk, would you please read the Open Public Meetings Act statement?
Adequate notice of this meeting was given to the press and posted as required. Date and time of this meeting was legally given as required by the Open Public Meetings Act. This notice is on file with the municipal clerk and posted on the bulletin board. Minutes of this meeting will be made available to the public upon the completion of typing and proofreading by the municipal clerk.
Okay, thank you. We're not doing a closed session.
Yes. So,
Are we doing a closed session?
no. So for the public, there was a closed session, resolution 17149. It's being pulled. Any discussion on the rice notice for Lizette is to take place at 7 or later. And Chief Chiappi also asked for his rice notice discussion to be in public. So we will not have a closed session.
Mayor, if I may report, Councilwoman Park arrived at 6:35.
Okay, thank you. So then are we going to wait till 7 for both of those?
We have to wait to 7 for minimally for Lizette.
You want to do Andy first now, or Chief?
Your call. Is he here?
I don't know.
I saw him before, but... You can move to Andy.
You know what, since the chief's not in the room, let's move over to Andy. Andy, would you please, this is our borough engineer, Andy Hiblet from Mazer Consulting. We've had several discussions regarding the P3 zone. I know the planning board's been working hard on this as well. And, you know, just to recap what I've said, because things get lost in this translation in this town, I said a couple things. And I think we all agree that the south part of 9W needs to be improved. I think the current guy here shaking her head yes. I think we agreed on that, and then we had discussed different ways to go forward. Andy's firm was good enough to go and review different options. The rehabilitation option seems to be the one that would best serve our needs. I don't believe in eminent domain. I don't want to take anyone's property away. I would never want to do that, but what I want to do is create the right environment for property owners in the market to improve what we have. So, Andy, I turn it over to you.
Thank you, Mayor. So, I think for council, because some of these were actually planning board meetings, some of you weren't. For council, just to find out how we Mazer really got to where we were. If you look at the documents available in the borough, there's a number of documents that are available. There's studies that literally go back to 2003, from Phelps by Shapiro, from Burgess, from Jason Kessler, all of them work in the borough, all very good planning firms. They looked at the B3 zone, just like Mazer did, and they came up, and we came up with the same conclusion. The zone is tired, the zone is underutilized. The current zoning that exists in the zone is not allowing for it to be rebuilt or redeveloped because it just doesn't meet with what the economics of the times show. And that's gone on for a very long period of time. And that's not, again, just me saying that. That's 3 planners before us saying that all the way back to 2003. We looked at their reports, we looked at the zone ourselves, we looked at the options you have to institute new zoning in that area, and there's a lot of things you can do. One is an area you need to redevelop. An area you need redevelopment comes with 2 swords, edges of a sword. One edge is with condemnation, and one edge is not, but either way, to do an area you need redevelopment, It requires a very high level of proofs, it requires years of public hearings, it requires meeting all these property owners, and ultimately, in a lot of cases, it requires having another developer come in and take the zone over and start condemning property. We didn't believe that was the right thing for the zone because the economics here lead you to redevelopment as long as you have the right zoning in place. And then we started looking at other ways to do it. Then we looked at zoning. So your other planners at some level that you had at the borough said, well, just rezone it. Create new zoning and rezone it. And that, good idea. We believe it should be rezoned. We believe that looking at it, you should rezone it. But when you rezone it, you have to blanket rezone. So if you want to change the FAR, it's the whole zone. If you want to change the height, it's the whole zone. If you want to have a use, it's the whole zone. If you want to have brick facades only, it's brick facades for the whole zone. If you want to have an outdoor bar on the roof, it has to be the whole zone. It's problematic in that zone because if you look at that zone, just drive through it. I drove through it tonight. You have everything from a building under construction to buildings that are almost boarded up to a couple of restaurants that do well. And I've been told they're good restaurants to kind of like a salon type place, the other uses there, and it's just, there's everything. You have a zone that has its mishmash of everything. So to institute blanket zoning across it won't necessarily work. When you look at the other plan reports, they kind of indicate in those reports also, including ours, that it's not going to be that easy to do. They talk about the other reports, shared parking, they talk about maybe changing height regulations, they talk about a lot of things, and we looked at all the reports because there was good data that was paid for by the borough under previous administrations. It was good data. So we said, well, how can you actually effectuate zoning that works, that's more specific to properties? The only way you can do it in conditional land use law, other than redevelopment, an area need redevelopment, is an area need rehabilitation. It's the only other way you can do it. An area need rehabilitation allows you to come up with a plan for the zone. It can be site specific, it can be one side of the street specific versus another side of the street specific. You can take one side of the street and split it in half, you can take the other side and split it in half. It can go right down and pick parcel by parcel by parcel. You, at this mayor and council, would authorize the planning board to undertake that. And they would come up with a plan. That plan would be for all the properties in the zone, however it was best to break it up and do it. It would come back to you for adoption of the zoning for that plan. So the same process as rezoning happens, it just happens under a designation that the state of New Jersey allows you to do. Probably the best example for me, because I live in the area, if you go to Morristown, Morris Township, if you've ever been there, Morristown is the center of the donut. Morris Township surrounds it, but it really acts as one town. 20 years ago, if you went to do the Morris Township, your values were hurting, and you wouldn't even go into Morristown. You were almost afraid to go. 20 years later, it designated the whole town, or most of the town, an area near rehabilitation. And by doing that, they were allowed to go site-specific. You know where the Bell Mansion was, or the Epstein's building was. They went site-specific, and they were allowed to look at facades and outdoor decks and restaurants. And they looked at offices use mixed with residential uses. And they looked at things like height and parking garages. And they were very specific because they said, if you look at Morristown in a blanket, it's such a mishmash of different types of denominational churches to different types of restaurant bars to offices. It didn't work. It didn't work, and the designation allowed them to come up with a way to do it. Now, listen, is your zone down there the size of Morristown? No. Does it have a train? No, it does not. But anybody can drive through there and see, you have so many different uses down there, to blanket zone it is going to be difficult. And not only the major report, but the other reports said the same thing. It's going to be hard to pick one FAR when you have somebody building a new building right across the street. It's going to be hard to have an FAR when you have two restaurants that are relatively successful. But I may want the restaurants to share parking because they're not allowed to. If I do a blanket shared parking across the whole zone, it might not work across the street. So it really throws in a real hard case. By doing an area rehabilitation, you're allowed to be site-specific. It has to go through the same process as zoning because it is zoning. So you'll come up with a plan. The plan could be this big. The plan could be this big. The plan could be this big, but it'll be specific to the properties to the zone, and then it'll come back to you for rezoning. And then you'd either adopt the zoning or not. You can do nothing. You can deem it an area of rehabilitation and do nothing. And that's the basis for it. It's a way that gets you over the hurdle. You've looked at it from 2003, and obviously nothing has worked. You've paid for now a fourth planning study, and the first three said rezone it, and nothing happened. So now the fourth study, which would be ours, is a different one. We've said the only way to effectuate it is to actually look at an area in need of rehabilitation. That's kind of the basics for it. I believe that the next step for you would be probably have a special meeting with the mayor and council to discuss this, because then you can get your public involved, and we'll talk in more detail about properties, and you can talk in more detail about how the process works. You would eventually introduce a resolution to designate an area in need of rehabilitation. That resolution would go back to your planning board. They would take one last look at it. They would say, yes, we've already looked at it once. We agree it should be an area in need of rehabilitation. They'd send it back to you. You would adopt it, and then you would start the process in your budgets every year to start rezoning each parcel or parcels or part of the street or the whole zone, however you want to do it. And it would, I mean, we know, Mazer, and I know we were hired by you, we know it worked. We've seen it work in dozens of towns. Your previous planners already said you would rezone. So this is the way to actually make your rezoning work and do it the right way. That's the short version.
Can you update us on what happened at the planning board meeting, at the last meeting?
So what happened at the planning meeting, and the area in need of rehabilitation is very much misunderstood. There was a lot of questions from the public. Some members of the public were here, and I thought we had a good discussion. It wasn't a bad discussion. But members of the public, and there was at least one board member, that really misunderstand what an area in need of rehabilitation is. They were throwing out words of devaluing the zone, of causing really a devaluation or a change of the zone to be like a lower class. You're going to just institute all housing there. You're going to put 5-story buildings there. They were confusing the zoning portion of it with the designation portion of it. There are two different designations. One's not the same as the other. You can't come up with zoning if you don't declare it an area in need of rehabilitation. The act of declaring it this body, and you have the power for that, allows this body to give the planning board the authority to come up with that zoning. And the questions that I was receiving there from both, at least one or two board members in the public, was this now opens us up to a co-litigation lawsuit. It does. This now opens us up to having a lot of housing there. It does. This now opens us up to having the restaurants that are closed up, they can't operate their doors. It doesn't do that. If you want restaurants to be maintained there, then put it in there for those two properties. Maybe, again, this doesn't happen yet, maybe the restaurants do allow them to share parking. And then they can both have more floor area and be more successful restaurants with outdoor dining. I don't know if you're going to do that, but nobody's planned it. You haven't gotten there yet. You haven't done that step yet. You know, I heard things like, oh, if we do this, we're going to have 5 stories and the top 2 stories will be all housing. It's the all low-income housing. I don't know why you think that. That's for you to zone it for whatever you want to zone it for. Granted, if you want to zone it for low income, you could. I don't recommend it. The other thing I heard was, if we do this, we're opening ourselves up to all COLA lawsuits. You know, coalition of affordable housing and that whole mess that's going on in the state of New Jersey. You're not. You're actually doing the reverse. So I'm involved as both the planner and engineer in a number of municipalities, which I said at the planning board. And the most vulnerable a town could be under COLA litigation is when you don't plan. So if one of the people in that zone would decide that they wanted to build something, your zoning doesn't currently allow it, because it doesn't. They would come to you and go, okay, I want to put up 30 units to the acre. Right now the state's giving away about 30 units to the acre at most courts on affordable housing. You would go back and say, wait, Judge, we have a plan. We've actually designated an area near rehabilitation. We've actually are working on zoning. We want to work with this property owner to come up with the right thing for them and for us, without just jamming all of affordable housing. We don't believe it's the right thing for the community. When you go to the judge and say, we have no plan, we have zoning that's outdated, it doesn't work, you're in trouble. I can't.
Which is the situation we've been exposed to.
Everybody, yeah, you're exposed to it all over right now. It's a big problem. If you have an area that you've tried to rezone, or at least have recommendations of rezoning, 3 planners before us, and no action was ever taken. And you now have another planner giving the same recommendation, just adding one other thing to it, which is you could make this happen as a mayor and council with your planning board if you designate it and then allow it to be rezoned properly because of the various uses. There's so many different uses there. You have 10 or 12 different, totally different uses. You have a hair salon across from a restaurant. It's really different. You may want, again, you might want outdoor dining. You may want housing there. You may want office there. You may want, professional corporate space like law space there or real estate space there. I don't know what you want. But you can't even get to that step because you have no way to get there. So many other reports talk about different types of uses there, but nobody's ever made it happen.
What were the reasons in the past why it wasn't adopted?
Well, I don't know the answer to that. I can tell you that previous administrations, at least one that I was involved in, really looked at it and said this is just too much of a kind of a bee's nest. If we start to look at rezoning and blanket the zoning of it, it might create things we don't want. It might hurt current business owners. We might create a zoning that forces a restaurant out, or we might create zoning that forces housing there. And they didn't want to deal with a room full of people. It's controversial. When you rezone something, it's controversial. What we are telling you is when you rezone under a designation of an area needed rehab, it allows you to be specific and work with the owners of the properties.
So you really are more protective when you do it this way?
You absolutely are. And I've been involved in it, you absolutely are.
Did you find at the end of that meeting, what was the outcome at the end? Did residents seem to have a better understanding? Did they not want to understand? Did they not want to, I mean, I don't know.
I think it was a mixed bag. I think some people understood, I think some people didn't understand. I think there's some people who don't want to understand, and I understand that. I'm involved in politics all the time. I get that part of it. But my job for you is to tell you what I think is best to get the goal of getting zones. Not look the way it's looked. Listen, I've been in the close back in the 90s. It's looked the same way since then. There's been a few improvements.
It's an excuse.
There's been a few improvements, but not a lot.
I have a question. So how do you stop, so if you make it site-specific and you allow certain property owners to, let's say, build a 3-family or a 3-story building, and then you have, let's say, a restaurant property owner who decides, you know what, it's probably more lucrative for me also to knock down my restaurant and build a 3-story, unit building as well. Like, how can you stop that from
Going to be allowed.
Right, so the great part about an area need rehabilitation versus zone. So now, area.
How is that?
I'll explain.
Yeah.
So the great part about an area need rehabilitation is you're allowed to, by law, be site specific. You're allowed to come up with a plan for the whole zone.
You don't think that's
No,
discrimination?
no, it's not. See, but
Spot zoning is the word.
yeah, no,
Yeah.
see, if you did it, the reason the other 3 plans couldn't get adopted is because it would have been considered spot zoning. It would have been considered being discriminatory. It would be considered a lot of that. The state, way before Indy even did what it does now, decided that this area need rehabilitation gave the town some flexibility. It's been tested, it's been tried, it's gone to court. Every time it goes to court, the judges favor the side of the towns, because the area need rehabilitation does one thing. It gets properties that are in distress back on the tax rolls. It's better for New Jersey, it's better for your town. So then you get to decide. If you don't want 3-story housing, you don't have to have it. If you want restaurants with shared parking, then you can have it. Now, can a property owner challenge you? I guess they could. Anybody could challenge anything. But the idea is to create an overall plan for the zone, and then you adopt the overall plan with all the properties together, or whatever they do. You're going to have synergy. You're going to want streetscape improvements. You're going to want sidewalk improvements. You might want outdoor dining, so you already have it out there already. You're going to want facades that are very similar. You're going to want signs. The signs that have synergy, so the signs look the same. You might want lighting improvements on the street. You might want to induce really friendly pedestrian walkways. In an area needed rehabilitation, you could actually write that in the plan. In zoning, it's really hard. It's really hard to say, hey, when you build, we want a light in front of every building. It doesn't necessarily work that way. Just plain zoning. A plan's a plan. The plan probably, when you're done, I would think it'll be about that way.
Yeah.
And it'll be an amendment to your zoning ordinance, and it'll be actually codified as an amendment with this plan being that plan. And it will have specific pictures of each side of it. It'll have specifics for it.
What exactly did the planning board approve?
So the planning board sent back to you a resolution telling you to introduce a resolution declaring an area needed rehabilitation. But the way the process works is you would introduce that resolution. It's now an open resolution, not adopted yet. It would go back to them one more time.
What was the vote on that?
There was definitely one no. I know that.
One no, and everybody else
What?
was.
It was one no. I know the no.
Everybody else voted in favor?
Yeah, and then it's public information. Ed Fair, who I know Ed for a long time, Ed had a lot of reasons why he voted no, and I told Ed there, at least some of his reasons, a lot of his reasons he was incorrect. But that's, I know Ed for a long time.
But I think you could I think some concerns I've heard, and I think you could put a lot of people's minds at rest. If people can understand that, to eliminate the killer spot zoning. So we're supposed to lay out the plan, what you guys can lay out a plan. So these are questions I've heard. So let's say you have restaurant A, restaurant B, house. So we make a plan for those parcels. And if the parcels choose to change, how is that? That's the concern people have.
Right.
What happens next?
Right, so the idea behind the rehabilitation, and there's a lot of success stories for that, okay, is you will create a plan that includes the whole zone, not just a parcel. So it's for the whole zone. It can be site-specific again, or street side specific, or half specific, whatever works best for you. So you might say, hey, we want in this area of the zone, on this side of the street, we want just restaurants. So we want to rezone this area to allow restaurants, traffic, dining, and shared parking. Just north of that, you may want office use. We want like office, small corporate, like lawyer offices and real estate offices, and that there. On the other side of the street, we may want, again, like retail restaurant on the other side of the street, and then we want the whole side of the street. And then you write a plan, and you're good. You come here, you adopt it, and you're good to go.
So
If you couldn't do that with zoning, just
I follow them, because I'm on board there, but I'm just trying to answer some questions, and I don't have the knowledge, so the next question would be, okay, so we have restaurant A, we have restaurant B, we have house, we zone for that. So if restaurant A now wants to become a residential parcel, is that allowed to change?
Well, they would fall outside the zone we would now adopt, they'd be D variance. They'd be a
So they
D1
can
variance.
apply for variance,
Anybody
just
can apply for
like we do today.
Anybody can
Same
apply.
way we can do, they can still go.
They can do it right now.
So, because I think that's a big concern, people are concerned that we zone it for whatever, and then.
You're stuck with it, you're afraid to get stuck.
Yeah, they would be,
Correct.
once you adopt that plan, they would then be what would be called a D1 variance, which is hard to prove. It's not an easy proof.
That was my explanation.
But they have to do D variances for that zone now?
Correct.
Majority of the
That's
men
the same.
They would, right now, anything you want to do would be a D variance.
will be a D variance.
A D1 or a D variance.
I think, Mayor, I know that you spoke about this before, I think it's gonna be very important, Andy, we appreciate, you put a lot of time, this is your fourth meeting on this, coming in, but you're very
I like
patient.
coming here.
No. If we could find a date that works for the council, and then make, publicly announce it so that the entire town knows, they can come out and have every question answered, and let's just work on a date.
Let's try to do that after Labor Day when everybody's back.
Yes.
Right, I just want to be clear again, because there is a misconception, and I heard it at the last meeting with some questions, is once this council would designate an area of location, the zoning is done. It's not. All that does is once you actually adopt the resolution you introduce, and the planning board talks about it and comes back here, all it does is now the zone's been designated, and then you have to start budgeting money in your 18 budget to start coming up with plans for what you want to do. So you're going to have, what the attorney's involved, you have planners involved. You're going to start developing what you want. There'll be resident meetings, there'll be commercial business, there'll be stuff that's going to happen to create that. Your planning board will lead that charge. And then that has to come back to you again for adoption. So unless you adopt it, it's never going to happen again. If they die like all these other four stuff.
So is there reporting, connected with the designation? In other words, we designate, is there a reporting we have to report to the state of New Jersey, or?
No, it's your legislation, your law. So you've designated the area in your rehabilitation, and now you've given yourselves the ability to send to your planning board to come up with a plan for it. That's all it's required.
So, some of the things that I've heard, the word, rehab, it definitely has a negative connotation. So, people thinking, oh my God, is this going to be bad with my property?
I definitely.
So that's one concern.
Okay, sorry, to tell you where the name comes from. It's not an Andy chosen name. What had happened was, when the state passed this legislation, and we really do this, that's the name they gave. So you have to follow what the municipal legal law says on it. That's
Right. So, another question that I have is, are there any downside of our designating or rezoning an area of rehabilitation?
Two
There's
questions.
got to be something.
Well, there's two questions. Technically, no. Because, as I said, if you designate an area of rehabilitation, you could just let it die and do nothing. So the current zoning would stay in place. So the worst thing that could happen for you as a body is you spent the money for Major, you spent the money for 3 other planners, and do nothing. That would be the worst thing to happen. You know, I think there's northern Jersey, like 14 towns that designate their entire town as area of rehabilitation, never did it. But it's still there. They can do it if they want. If they have a property that becomes in total distress, they can address it, but they don't have to. As far as rezoning, again, the process of zoning, because I heard that scare at the meeting, that you're subverting the process of zoning. You're not. What you're doing is you're going to actually come up with a plan that can be more site-specific, and then come back here and adopt that zoning ordinance. You're going to adopt it the way you adopt any other
You're
ordinance.
saying it's a procedural measure in other words, we want to do something, we need to designate first.
Correct.
So that we can do something.
Just a
right?
procedural measure. That's a great
Yeah.
example.
But if you look at what we have down there right now, it's really not working.
It's not working.
Andy, if, every property owner there is gonna have their own interest in mind, right? So let's say somebody owns a restaurant, decided he wanted the outdoor patio and this and that. His area was zoned for that, and then someone else all of a sudden decides they want a 5-story building next to the restaurant owner, and suddenly that patio gets covered up, because, you know, we have the flexibility to do what we want with the different parcels. How do you deal with that kind of situation? Because it's sort of a timing issue, right? Some people are first, sort of first come, first served. Some people are, you know, coming into the process later.
Right, so what I heard the planning board meeting also, from really a public perspective, some board members asked the question, was the same question, basically. And again, when the plan for the zone is developed, it's for the entire zone. So you're gonna come up with a good plan. We don't wanna put bad planning first after bad adoption of an ordinance. We want to put good planning first, then the adoption of good ordinance second. That's the order it goes in. Could somebody be zoned for a restaurant or outdoor dining, and the guy or no next door doesn't take their building down so it's shaded? Well, yeah, they might not get there, because you can't force them to redevelop it. You can't force it.
Or rehab.
It's gonna happen, yeah, well, yeah, it's rehabilitation, but they're gonna redevelop the property. You can't force them to do that. Hopefully, as you see the successes in other communities, people see the value of this. I don't know, property owners are here, most people don't want to lose money. I don't want to lose money, so if I have the right opportunity to create some new, buy my property and make some money, most people will do it. It may take 5 years, it may take 10 years, but you have to start it first to get started. You know, your specific question, restaurant that's a 5-story building, well, you guys would have to approve that. If that's not what you want, you're not going to approve it.
Right, exactly.
You have to go for variance, just like every.
Right, they have to go for a variance. So I think in the success stories I see, again, I kind of go back to Morristown. I lived there. I went there all the time. If you go back to Morristown 10 years ago, it was a disaster. Now, I walk into town from Morris Township with my kids, like 10 and 12-year-olds, because it's safe and it's lit and it's pedestrian friendly and the buildings are all the same height and they look the same, the signs are the same. You can institute the same thing coming from Fort Lee to Anglo Cliffs.
Do you know of any towns in Bergen County that,
So
that have, you know, rezoned for area?
There's a bunch of them. I think Ottawa has the designation. I think Paramus has the designation.
Could you please talk into the microphone so we can hear you?
I think Ottawa has designation. Paramus has designation. I think Oroville has designation. There's a number of them, but a lot of them either acted on it or did not.
Do you know of any towns that have acted on it? That we could maybe, you know,
In Bergen County.
yeah, in Bergen County that we can maybe, you know, go take a look, perhaps.
You know, if you want, I can get this for you. I can get some for you. I mean, they're there.
It would just be nice for us to say the residents of this town ABC did it, and how nice it was.
Anyone else have questions?
I just want to add something. So I got a call.
Microphone, please.
Oh, sorry. Thank you. I got a call this week from the judges' chambers on the COA litigation. So they're calling us in for September for status. So I don't know if that means the litigation is going to, I mean, it's not really litigation because we don't have anyone filing against us, but it is the affordable housing judge that's handling it, and it's affordable housing. And it sort of indicated to me that it's been laying dormant for at least 6 months, if not longer. And, you know, the planner from Mazur's office has to go, and I have to go, and the special master has to go. So that's going to probably result in some dates
Can you explain what a...
and expectations.
Explain to the public.
Yeah, so, you know,
Who's your master?
Lon, I don't remember. Lonigan,
Mary Beth?
Mary Beth Lonergan or Lonigan. You know, I wasn't involved in the beginning.
Mary Beth Lonergan.
Yeah, that's it, Lonergan, right. I wasn't involved in the beginning. Fred Zemrow did pick it up from the previous attorney, who I think, in any event, there's 5 Redwell holders of it. During the course of an affordable housing, what it is, you know, COA collapsed. It's no longer the actual law of the land. Now we have judges that have to do them. Englewood Cliffs filed to become protected by against builders remedy lawsuits. You had to file by a deadline. The vast majority of New Jersey municipalities all filed, you know, on the same day. And a special master is appointed, which means she's a planner, or he's a planner, and they are meant to be the last call in recommendations to the judge, etc. You have your own planner. If there's anyone that is in the litigation, they might have their own planner. But it's the special master that makes a call on, we recommend this property should be considered for affordable housing, or why aren't you doing enough to meet your obligation, etc., etc. So I expect that I will get a feel with respect to where she is. And I've never seen a special master report. Our planner's been working on it, but I don't think they've gone to a special master report yet. But in any event, it will come. So, you know, one of the things that Andy talked about is, you know, this is a way to get some movement, but it's not a forced requirement that any property owner do anything. It applies if you have a rehab and then you do the rezoning. It's only going to apply if the property owner wants to do it. It's not us telling them you have to do this. It's going to apply when and if there's a transfer of ownership. Maybe a builder comes in and wants to look at 3 or 4 parcels, makes a deal with a property owner, and wants to follow the plan. Because most of them like consistency, right? But you know, a property owner that's just sitting there with a vacant property doesn't have to do anything unless, you know, we start saying condemning it and because it's in bad shape or something like that. So it's another tool. It's a tool. And it sometimes does take 5 or 10 years to see the results.
Anybody else? Thank you, Amy.
I guess you'll just stay for
Yeah.
Yeah, would you mind?
That's fine.
Maybe a do-over. Yeah. If you, our planning board chairman, Mr. Carino, is here, would you like to add anything?
Unless anyone has any other questions, I think Mr. Hipwood carried the conversation very well. Unless it's questions.
And again, we are going to have some special meetings, at least one, for the public to come. We'll do that after Labor Day, when everyone is back from summer.
Mayor, for the record, I'd like to point out that Councilman Aversa arrived at the meeting at 6:40 p.m.
Welcome, yes. Chris, did you want to? Okay, so, Amber, should we open to the public, or should we take care of the residents?
What's next?
Well, we're back at the top.
Oh, yeah, okay, we're back to the top.
We're back at the top. Let's go
Mr.
public.
Corbin,
I'm back here,
okay, you're here, sir?
been here since 6:30.
Okay, thank you. Sincerely, your truth.
Let's do that.
The system is continuing. It's fine, you can drink. Mr. Carbone, would you like to come up?
You want to hear all the, I don't need to, you can sit here. I'll go in there.
Oh, she wants you over here. Sir, you can come in up here if you prefer to sit at the table.
I have no participation.
Okay,
This is your discussion.
okay,
Under 10.4.12.
Okay.
So welcome.
Thank you.
So, what we're doing right now is, one of the more frustrating things about being mayor is that you're not allowed to speak to employees unless you give them notice if you're going to speak to them about their performance. So in terms of our borough clerk, Ms. Duffy, I was required to serve a notice, which is called a rights notice. And in that notice, the employee has the option of either being heard privately in closed session or publicly. Ms. Duffy chose to be heard and hear me in public session. There's really one issue or two issues that was discussed tonight. Amory may be one. I'm just going to mention that, you know, in terms of what we're doing here, there's no discipline. We could have just done this privately as well, Mr. Carbone, that you chose to be public. It wasn't.
That's our right.
I understand that. You're welcome. We'll do it publicly. So if the public could, you're welcome to leave and have your conversations outside, come back whenever you want, but lowering is dependent on. So, again, we're here in public, and there, in the last meeting I mentioned that there's a lot of litigation, it's a very litigious town. We tend to manufacture our own problems. But for the grace of God, we don't have the problems that the rest of the world has in this town, so we manufacture our own. So we have a lot of litigations. And in terms of mayoring, I have to manage those litigations along with the borough council and our litigation council. And in one specific instance here, there was a plaintiff who was an employee of the police department who asked under his Oprah rights for a record of all the Oprahs that were provided to anyone for a certain time period. And when the discovery in that litigation proceeded, for anyone not familiar with litigation, basically there's a complaint, there's an answer, there's discovery, and the plaintiff asking the defendant for documents and information, and vice versa. So in terms of the borough asking that plaintiff for information relevant to his case, I saw in about 1,500 documents, some of the documents were documents from our clerk to that litigant who's still in the town while he's employed here. And some of those documents can be useful to that individual in his litigation. And the thing that upset me was that there were handwritten notes on those documents that were produced. That's not what was asked for by that litigant. The litigant only asked for a copy of any other Oprah requests. Those deliberative notes belong to the borough, to the clerk, and maybe it was inadvertent, maybe it was unwitting. I'll assume it was. But this is my message to the town and the borough employees. We need to stop these litigations, and we need to defend them. And to defend them, I need to have things done in a certain way. And Lizette, I thank you for the work that you have done with us. This may have been an error, witting or unwitting, and I know you're friendly with that person. Not all of your Oprah productions included notes to some people and others did. So just going forward, just if somebody asks for everyone else's Oprahs, please just produce the blanks that you received without any kind of deliberative notes or indication of which way the borough is thinking, what the mayor's doing, what the borough attorney's doing. It would be very helpful, right? Again, we could have done this privately, but you have the right to be here publicly. And you're free to comment as well.
No comment.
Did you have anything?
Can I ask questions?
Oh, did you have anything?
No,
Okay.
you said it fine.
Because this is the first I'm hearing about this, other than the actual agenda, so, I know you can't talk about what litigation or whatever, but how long, can you at least say, was this something that occurred this year, or last year, or years ago, like, what
When did it occur?
Well,
I'm not sure, I didn't see the document.
This is, these documents that the mayor is referencing are from very recent discovery.
So pending litigation.
Yes.
Okay.
And we're not talking about the pending litigation here, and we're not talking about any
You're
other.
not talking about something that was,
I mean, look,
like,
the-
years
It's
ago.
just
or
asking
anything.
When would the
Yeah.
Yes.
documents received?
In the beginning of this year, and I just received them in the discovery process in the last couple of weeks. So look, the underlying litigation, I believe, is completely frivolous, but that ever may be, we still have to deal with this other stuff. All right? Anybody else? No, thanks.
Mayor,
Sure.
as you are aware, I did counsel the employee on that matter. She's aware of it. She was not aware of it prior. I explained it to her, and it's a procedural issue. She understands that this procedure is not to go forward, so she does understand that. It is not.
Thanks very much.
Thank you. Okay. All right, thank you. That's it.
Okay, we also served a rights notice to Chief Choppy for different reasons, but also relating to litigations.
Is he here?
I saw him, no, I don't see him. I see his attorney.
Okay.
All right, you know, we could open to the public or,
Okay.
have a motion to open to the public?
Second.
All in favor?
Aye.
Okay, is there anybody from the public that wishes to be heard? While we wait for the chief to come back? Yes. He had his hand up first, and we have a citizen come up. So come up to the microphone, state your name and address.
David DiGregorio, 165 Charlotte Place. Mr. Mayor, I have to say you are a real leader in the truest sense of the word. Look at all the mess that you have created in this town. What a mess. This one is suing that one is suing this one. No visionary thinking. Absolutely shameful. And you're smirking right now. I listened to your interview with Curtis Steele, that wonderful intellectual that is on our airwaves. It was absolutely disgusting. You insulted probably most of the police
So
department.
I think we should stick to issues.
I am. That's an issue. That is an
No,
issue.
those are your feelings.
No.
Facts have no feelings.
Oh, so what you said to Curtis Steele was not a fact? That you resented salaries that were negotiated out of your control?
We have honored all our financial obligations with the
Right. So you go on radio and you say that's why you have a problem with the police department and with the police chief. It's all very
Do you have
clear.
anything else to say?
Oh, I have plenty to say. Plenty to say. Want to say more?
It's up to you.
Yeah,
It's
go
your
ahead.
mic for a minute.
So the other thing is, Charlotte Place. You're paving Charlotte Place. You've got a danger going on there. You've got to slow the traffic down. With speed bumps, you put these signs up for speed. Let's make that street safe. That's where your
Well, I agree
school
with
is.
you. We actually agree on that, and I did reach out to the police department several times, because you're not the only person complaining
Good.
about Charlotte, Summit. There's a few other streets as well. I can't get involved in police operations. So,
Okay.
you need to
Well,
keep
it's being
complaining.
paved.
Keep complaining, all right?
Okay,
That's
well,
all I
I'm
can
making
do.
a suggestion.
Keep complaining.
Now, this other spectacle here with your borough engineer, what's Andy?
That's not fair. That's not fair.
Is he here?
He's a hardworking professional.
Okay, who pays him? Who pays the borough engineer?
The borough.
The borough pays him. Who does he work for? Who does he work
Get
for?
to your point. You know the answer.
You can answer me.
Okay.
Who does he work for?
Let the borough attorney. I mean, I told all the council members, this is not a back and forth question and answer.
Okay.
Unless a
Then
council.
I'll just say what's on my
Excuse me.
mind.
Unless a
Okay.
council member or the mayor wishes to
No,
respond to you.
just say what's on your
So,
mind.
Okay.
just say what's on
So
your mind.
what a spectacle, and I'm going to be critical a little bit of the Democrats also. You have a person here who's being paid by a private company, and that private company, is the private company being paid by us, or is he being paid by us? Those checks are being made out to who?
You know,
I'm asking, who are you making those checks out to? Mazer, okay.
It's been that way
Do you
for
Good.
understand?
years.
I understand. I
What
understand.
is your substantive issue?
My issue
Stop
is,
attacking people.
my issue is that you have a person here who is giving you advice that you're paying, right? But he's not working for, you're paying Mazer, he's working for Mazer, that's a profit-making company. How do you know the advice that he is giving you is, number one, accurate, number two, good for this borough, and in the interests of all the people standing out here?
I think the advice has been very good up till now. I have no reason to doubt him going forward. You haven't stated why you don't like his advice still. You've attacked him.
There are
You've attacked him.
many reasons, and.
Give me one substantive reason.
One
If
of
you have a
them-
microphone in your hand.
One of them is the field out here.
Okay, you missed that meeting.
Whitty Field.
Right, you missed that.
Yes, I did.
Yes.
But I watched on TV. And I also watched on TV a spectacle of a mayor bringing family members of council people and others into this forum. Disgusting, Mr. Mayor. You're disgusting to do that. You don't do that as a professional.
Your time is up.
It is up.
Is there anybody else who...
Did you time it? Where's the time? Where's the time?
Well, no, now you're not talking substance. You're
So,
talking...
I will give you another chance. I want you to apologize to all the
You know,
people
I think you
where
are...
you brought the family in.
Why don't you just sit down now, okay?
I'm not going to sit down.
Well,
Yet.
We'll let somebody else speak. Is anybody
Okay.
else wishing to be...
Recognize somebody else. I said what I had to say. I don't know how you put your pillow on the, put your head on the pillow at night, because you are bringing personal matters into things. You are not a decent human being.
And you don't,
Thank you.
and you don't do that, do you?
Here, take that.
Please. Okay. Yes.
Janice Snacker, 392 Chester Drive. I discussed this with Mark, but I just want the mayor and council to be aware that the renovations of the curb, okay, on Charlotte that have been done, our sprinkler system, kids and, have to be,
Damaged.
yeah, because they've been damaged. And I've spoken to Mark, and he said that you would be responsible for that in a timely fashion. Otherwise, he said, otherwise, if you can't pay a sprinkler person, I will have my irrigation will come, and you will pay the bill.
So the same thing happened to me years ago. Everybody did. Yes. Mark, you got it. Is it possible to tell the contractors to avoid sprinklers?
When you put, someone so close to the curb line, they're all responsible for everything, that's the direct effect.
Engineers are going to...
For my neighbors.
A couple times.
Just for residents on the job, if sprinklers are put within 10 feet of the curb in the borough right away, they're there. If we're damaged, they'll be fixed using million measures. If the contractor can't fix them, we could have you get a price and we could authorize it and then he'll pay you.
Okay. Yes.
Maureen Eastwood, 4 Willow Drive. I find the criticisms of Mazer Consulting rather curious, since the same people had nothing to say about Boswell Engineering, which had the same fee arrangement. They also had nothing to say about the fact that Boswell Engineering, or specifically the borough engineer, wasn't Boswell Engineering, it was Stephen Boswell, although I've never seen the man. Bernie Morandi always came. They had no problem with the fact that Stephen Boswell was on the board of directors and had a substantial holding in Connect One Bank, just like Joe Parisi. Nobody seemed to be concerned about that conflict. Nobody seemed to be concerned about the fact that nothing was ever said about the Morrow Road flooding, even though I learned after I was on the council, because no one ever told me about it while I was on the council, or any other issues that were ever brought up about Boswell, which just got swept under the rug.
Yes.
So this is why I went to Hollywood.
only thing I want to talk about right now, and I'll save the rest of my comments for later, is that I was at that last planning board meeting, and I urge all of you to watch the tape, because half of what was just said that happened, didn't happen. And the one thing that did happen, and one complaint that many residents had, was a concern that one particular property owner, who had several properties in that zone, was going to benefit. So that was the biggest concern of most of the residents in this town. So look at the tape, so that you know exactly what happened. I'm not going to give you my version, I'm just asking you to watch the tape, because what you just heard was only 50% correct.
Anybody else?
Yes.
Hey, Mr. Mayor.
If you want me to, I think you may want to.
Well, because she said what you reported to us was only 50% correct, so.
You've now been called a spectacle.
So if that is true, I'd like to know about that.
You can look at, I gave a recap of what happened.
Right, but Mr. Barry just said that everything you just explained to this council was only 50% correct. Do you have a response to that?
What I said was exactly what happened that night.
But it wasn't everything.
Well, I can't cover everything, it was a 4-hour meeting.
It was a 4-hour meeting.
You just covered what you wanted.
I'd like to talk about,
What's your name?
oh, I'm sorry.
Sorry.
Falls into my minor place. There's not too many families that have given or that have worked hard for this borough as the Duffys. I had the absolute pleasure of working with Steve Duffy on having a board of adjustment for 16 years. Very diligently, very intelligently did we make decisions. Except, for tooth and nail to everything in this town. I've been, witness to if we needed a refrigerator for something, let's get on the phone and make all these calls to get the lowest price, and how she did it most times, I don't know. She got basically half price. Anytime there was any fundraising that needed to be done for the betterment of this town, it said it was the first to do so. So, we talked about, with after the election, there was an article, and they asked me why I ran. And I said I ran because the last time the power shift changed, everybody got fired. And I didn't want to see that happen again. And Mayor Kranjak said that he would only review the professional contracts that you have, and make changes. Good, bad, or different, you make changes. But since then, Paul and I was like anonymous stuff. And I just think,
Where are you getting this? What are you talking about?
the rest.
She wasn't let go. You understand what that is? You understand what
She was reprimanded. She was reprimanded.
You were sitting there, and I said I wanted to explain an issue. There's no discipline. The words "no discipline" mean anything
Okay,
special
that's
to you?
good. Thank you. I appreciate it. Okay. So, I just was concerned about that, about our employees who have, bills and mortgages and car payments like we will. That's it. I'm glad you clarified. Thank you very much.
Yes, sir.
Russell Perino, 220 Fairview Avenue. I'm speaking now as chairman of the planning board.
Thank you.
We had a extensive meeting this past month regarding the B3 zone, and specifically whether or not we should be recommending to this council that you should find that area needed rehabilitation or not. And the substantive process that we went through, I think Andy Hippolyte covered very well. There, quite a few residents did speak about it, and there's some concerns about stigma. I think this is a good word, and concerns that, that in itself, the word would somehow infer that the Borough of Englewood Cliffs is less than what it is, or could be. That the residents, the owners' values would be diminished as a result of the finding. And I think we did our best, including Mr. Hippolyte and another representative, Christine from from Mazer of explaining how actually the opposite can and should happen. There was a discussion, as it was brought up, about one owner who owns several properties that are in less than stellar condition. And we let the residents speak about it, and what I would urge those folks that there's a means of dealing with property maintenance issues, and that's really through the building department, the property maintenance director. We, as a planning board, don't have the authority to crack the whip and say, you need to clean up your property. We're trying to find, the planning board is trying to find, the means forward to effectively rezone the B3 district. And we believe strongly that the right way to do it, and really the only way to do it, is with find first the area in need of rehabilitation. Because otherwise, our hands are tied. We've got to rezone the whole district one way. We can't do spot zoning, and because of the different property sizes, and the different setbacks, and the proximity to homes that are located nearby, you can't have one size fits all. And that's really what drives, in my mind, and I think the board supports me completely, and our professionals as well, this finding. That's what it's about, is that the properties are not all cookie cutter in size. One size cannot fit all. But I want to make it clear that, yes, the residents did have a perspective, and they asked their questions, and I hope that we answered them successfully. And if we didn't, please come on out to any of our meetings. We have one tomorrow night, we'll have another one a month later. And voice your concerns, and we'll do our best to try to explain, to the best of our knowledge, how this works and why we think it's the right way to proceed. Thank you.
Thank you.
And again, I appreciate everyone's input on that issue. While I think we all agree that no one's come up to any microphone. No one's ever come up to any microphone in any meeting and said, that area looks fine, we don't have to fix it. No one's done that. How we fix it is a matter of discernment, and that's what we're doing now. We're talking about it, just like we did with some other things, including the field. I think we found a nice compromise there that most people appreciate it, if you don't, but you can't make everyone happy. Anybody else? Yes.
I'm Natalie Ashmore, by First Street. Can I ask a question to someone from the planning board? Is that okay?
The planning board meets tomorrow.
No, you can ask that.
Okay.
Yeah,
I apologize if you addressed this prior to me arriving. Is there a reason why this section wouldn't have just applied for a variance as opposed to a rezoning?
The B3 zone?
Yes.
So I think, as I said earlier, any property in any town in New Jersey can apply for a variance to redevelop their property, rebuild their property. The problem with that zone is, going back to probably the 80s, the zones look like that, and the owners that are in the zone have chosen to only make very minor modifications or upgrades somewhat, and a lot of times the properties that were there were upgraded and then failed. Some of the restaurants are doing okay there, and there's some things that are doing okay, but overall the zone has looked that way for 35, 40 years.
Okay, so, and I'm not being facetious right now, I'm literally asking a question. So if you're telling me that if I abandon my property and I leave it to go to crap, as opposed to saying the word I actually want to say, then somebody comes in and says, you know what, I really, really don't like the way that looks. So let's rezone it so that something else can go there. Now, I'm going to be rewarded for not taking care of my property financially, because obviously if it's going to be rezoned, something much more than residence is going to go there, right? So it just seems unfair that that person will benefit from not taking care of their property by having it rezoned and having something commercial go there, which will up the value of the property. And again, I'm just asking a question, I'm not being facetious. It just doesn't seem fair.
I think it's a good question. So you're mixing in personal people's gain versus a town's gain.
Correct.
When the properties sit the way they are in somewhat in disrepair and are collecting less tax money for everybody. A municipality has the ability to come up with rezoning. We recommended using any rehabilitation. Come up with rezoning and get the zone redeveloped the right way, or a way that you want to see it done, and then that zone will generate more tax dollars, you would not look at that. How they benefit, yes, are they going to benefit financially? Anybody who does their property
So
benefits.
I guess,
It's
I
a
must
private
not be
property.
understanding, and again, this is not, I'm not being facetious, I'm serious. So why couldn't it be done with a variance?
It can be, but in the world of planning, the worst thing to do is to redevelop properties by giving variances, especially use variances. That's exactly what you don't want to do. The state makes the towns report what variances they're giving out, because if you're giving out too many variances, your zoning's not working. You want to plan properly, not plan by giving variances. That's contrary to what the state wants.
But that doesn't change once you designate it for rehabilitation zone. In other words, you can still keep applying.
Anybody can apply for a variance
Right.
anyway. Just give people
So
a
then,
vision.
so then does that apply then to the restaurants that are on that boulevard as well?
Applies to everybody.
It applies to the
Applies
whole
to-
thing.
applies to the entire municipality.
But it doesn't apply to, the property across the street from me that looks like crap for the
It
last
applies
5
to-
years.
it applies to everybody.
Yes, that's, now I'm being facetious.
No, we understand what you're saying, that's why we want to fix it. Mr. Basil, we,
Ashwall, it's okay.
so, you know, those are real problems. I think, folks, you use the word abandoned. They look abandoned, but they're still legal owner, so.
No, I'm referring to abandoned as in the property across the
Yeah, no,
street from me is
yeah, it looks
abandoned.
abandoned.
No, it's not look abandoned, it's abandoned.
Somebody still owns it, so from a legal
Yes.
point of view, somebody still owns it.
But they don't take care of it, so therefore it's an eyesore to me.
What we've been doing though, is in trying to enforce the property maintenance codes that we have.
Okay.
And that's been something that we've been on top of. There's courts involved, it takes a while, but, you know, I think hopefully.
I can give an update on that
Yeah, go
if
ahead.
you want.
You want to?
First of all, you're absolutely correct. We can only control what's before us right now. I agree with you. I haven't been here 35 years, but hearing from everybody, it's been in many of those properties have been in disrepair for more years than I've ever been here. And quite frankly, it's unacceptable. I know one of the property owners is here tonight. Regardless of what happens here, and whether or not, how this gets approved, what happens, the properties are going to be in compliance, and we are going to be holding everyone to whatever is required of how they're going to be maintained. I appreciate your patience. I can't control what happened in the past 20 years. We are working on it. I happen to meet with the administrator today in the building department. There are meetings scheduled, and it quite frankly doesn't matter what this vote is going to be, because those properties still have to be in compliance, and they have to look presentable for this town while it's figured out. And, you know, we apologize for what happened in the past, but we weren't in control of but we're on it, but this takes a little time to change it. You know.
I have one.
Sure, of course.
So, just to be clear, I was talking about the C3 zone, and then I'm talking about my block. So that's two separate issues. So, on my block, I have a property that's, I'm on First Street. So, I guess my question is, in my mind, if you're gonna do that for 9W, and I understand that that's been happening for over 25 years now, and to be honest, that's my section of town, so I would like to see it cleaned up, because I tell people I live in Engle Cliffs, and, you know, it's kind of like, that's where they turn to come to my home. It is an eyesore. But specifically on my block, I have a home, yes, it's an empty lot, and it's not been taken care of, and it's now used as a dog park, because everybody walks their dog there, and it's not clean, and it's gross, and it's...
Can you send us the...
Sure. That would be
There's a
fine.
house that was knocked down, and the property.
Well, it was knocked down because I called to complain about the fact that people were doing drugs in it and hanging out in it, so, yeah, that's why it was knocked down. But,
Happened to me.
on a separate note, I would like to thank, and I know this is gonna sound like I'm making it more dramatic than it is. I understand that you, sir, Mrs. Duffy with a rights notice, I understand that you did it, and I understand that she chose to be public about it, but this is now the second time in the history of me living here where it seems like she's, please, I'm not insulting anyone, it seems like she's singled out and scapegoated. So as a personal response, I'd like to thank you, because I have watched you since our kids were in kindergarten, and I have seen what you get to this town, and I have seen how much you care for it. Even when you and I actually didn't even get along for a certain point in time, okay, I want to thank you. And I apologize, because I know you don't want to talk about feelings, but I felt like I need to do that, so thank you very much for it.
motion to close the public.
Yeah. Second.
Sorry, wait a minute.
Hand up.
Okay, that's, it is here.
I'm one of the residents who attended the planning board meeting, Mr. Green.
What's your name?
Very lovely meeting.
Excuse me, you have
Oh,
to
I'm
put your
sorry,
name.
Karen Geiger, 278.
Thank you.
Unfortunately, the meeting that I attended and the meeting that Mr. Hippolyte described were not the same. But I'm not going to discuss what Mr. Hippolyte said at the meeting right now, or what the residents had to say. I'm going to talk about my beliefs about the B3 zone. Since, Mr. Mayor, you chose to say that I come out and complain about the way it looks, I don't complain about the way the B3 zone looks. I complain about the way a single property owner fails to maintain his or her property. There are several homes in that area that are a disgrace. They are not maintained up to the standards of our community. And that is my source of complaint about the B3 zone. At the planning board meeting, I went through each building in the B3 zone and described them at length. Most of those buildings, many of them are new and have recently been rehabbed. Most of them are thriving businesses. I'm not saying that changes are not needed, and I'm in favor of rezoning, but that's what the MLUL is for, the Municipal Land Use Law. It tells you how you can rezone properties, and the borough and the planning board has the ability to make changes. I'm not going to speak as to why prior studies were not implemented. I don't know the reason why. But those are not bad studies. And sometimes it's not a good idea to reinvent the wheel. My own personal opinion is that the borough has not met the threshold legally for declaring that as an area in need of rehab. And I suggest that your lawyers look at the law before you go ahead and do that designation. However, I don't believe that you go and reclassify and spot zone properties where the owner has been negligent in meeting their obligations and thereby raise the value of that land. And I certainly am concerned, unless I hear from each member of this mayor and council, about height. I don't care that they will not be high rises. I don't want anything over 35 feet along that street. And I will go to court if need be to maintain that 35-foot height limit on that street. Thank you.
Anybody else? Got a motion to close the public meeting?
Second.
All in favor?
Aye.
Let's move forward with the,
No,
let's move forward with the rights notice to Chief Chaffee. Again, one of the more frustrating things about being mayor is you can't speak to employees about certain issues without notifying them in advance, and then they have choice of doing it publicly or privately in closed session.
Excuse me, Mayor, let's just note that the chief is present and his counsel is present.
Yes, what's the council's name?
Robert Gallantucci, right? That's his name. Thank you.
Okay, so, along those lines, a rights notice was served, and what I want to say up front is, it's of paramount importance to me that we protect and safeguard all our employees and their confidential information, which includes protected health information and other very sensitive information. And what you'll see here is an example of why we would need a public safety director. I spoke about this last month rather, and this kind of ties in with it. So I'll give you the backstory. What happened was the chief has sued the town. We're not going to talk about that here because it's pending litigation.
Sorry, I just don't know how to, you don't have to recuse unless we're going to have some kind of discussion.
But in terms of that pending litigation, as I said earlier, there's discovery. So there's a complaint, then there's officer, and then there's discovery. Plaintiff gets to ask the defendant for relevant information, the defendant gets to ask the plaintiff for relevant information. And in connection with the information that we, on behalf of the borough, received from the chief and his counsel, about 2,000 pages of everything but the kitchen sink, there were some documents in there that not only touched upon, but disclosed protected health information of our employees, which were irrelevant to the case that they were being produced in. There was a letter from the chief discussing internal affairs with the plaintiff's attorney, which happened to be the chief's former attorney from years before. That was confidential information. And there was also a highly sensitive bit of information in there regarding yet another, actually, officer, which should not have been disclosed. All three of those things were completely irrelevant to the case that Mr. Galantucci has brought forward against the borough. So, look, it happened. I'd like Mr. Galantucci and the chief to try to unring that bell, and I'm going to just ask you right now, will you indemnify the borough, because I have to deal with this now?
Indemnify the borough, no.
Okay, thank you. So, touching back on what I said last month, if we had a public safety director who would safeguard our employees' records, and I imagine the PVA is going to be jumping up and down about this as well, although I haven't heard from them yet, this could have been avoided. I don't know how our police department maintains its records and protects those records, but I should not know about certain health conditions of our officers, and neither should any other litigant involved. Okay? It's irrelevant to the case. And if it was law office failure by Mr. Galantucci that produced all this, then he's culpable as well. And from the borough's point of view, I intend to assert our rights fully, because that's my job. I have fiduciary duty to this borough. Now, our borough is the covered entity under HIPAA. We hold that information. We hold that medical information. You're shaking your head, yes, right? So we hold that medical information in trust. It's not for any employee to take and try to self-serve themselves with that information, even if it's irrelevant. So all I'm asking right now, other than getting indemnified from the chief and his attorney, is can you just look at your practices and procedures to make sure that the members of our police department are protected fully when it comes to their personal health information, their diagnoses, any other confidential information, because that wasn't done here. And now I have to notify those people that that wasn't done and deal with it. Okay, and again, that makes my case further for the public safety director. Now, in the letter to the attorney, that was just simple coordination of lawsuits between two employees of our borough, and that has to stop also. And I mentioned that last week. That's all I have to say. That's all I will say on this matter right now. I reserve further comment and action. And we should make it the cars.
Not unless you want to. Chief, do you want to respond in any way?
Yes, sir. Do you want a microphone?
I don't need a microphone. I'd like to know if the council has discussed the issuance of this rights notice before this evening.
I have not.
I want to know if it's a governmental action.
You're not here to ask us questions, sir. You can say
If there was no discussion about this issuance of the rights notice, it's a violation of law.
No,
That's number one.
the violation of law
With
was you
respect to
disclosing the
discovery,
personal health information.
With respect to the discovery,
Protected health.
we'll deal with that in court. We're not going to deal with it when you have a microphone here. We'll deal with it in court. You're wrong again.
Okay. So you explain that to the officers. You'll be witness number one.
Yeah.
Okay.
It's information you already had, or certainly should have had.
Did the public have it?
It went to your lawyer.
How it works.
Not to the public. It went to your lawyer.
The Did you say it was a misuse of information?
No,
You don't think so?
no,
Was it relevant to your case?
yes.
Yeah? How?
No, that's okay.
All right, they don't want me to ask that question.
No,
All
we're
right.
not discussing
Mr.
pending.
Gallantucci, it did not just go to the lawyers, and you know that.
I don't know that at all.
Well,
When you do that, make sure you tell your
no,
co-counsel.
it did
All right.
not go to the lawyers.
I'm sorry.
I'm just for the
All right.
record.
Why is she
Commenting on police
She shouldn't be.
Why don't you stop talking out of turn?
I'm sorry?
Why don't you stop talking out of turn? This is
Why is she speaking first?
She has no conflict, sir.
Both? Round. I told you.
Okay, we're not discussing pending litigation in any detail. This is not a discussion about the pending litigation.
It's hard being a plaintiff and an employee, I understand that, but you still have fiduciary duties, and so do you, Mr. Gallantucci, because you're representing him in this borough, to not disclose protected health information, other confidential information of our borough's employees.
We'll deal with it in court.
Of our borough's employees,
We'll deal
okay?
with it in
If
court.
no one else is gonna protect these people,
court.
I am, okay?
In court.
Okay, I know you're not gonna
Last
protect them,
word.
I don't expect
court.
you to, because you're just there to do your job, and you're not doing it very
No,
well.
that's not true. We'll deal with it in court.
You're
And
creating
that will be
more
the final
liability for
word. That will
everyone.
be the final
You're
word.
creating more liability for everyone, okay? I suggest you
Creating more
review,
lawsuits for everyone.
before you proffer your discovery, I suggest you spend a couple of hours looking through what you are proffering, and making sure that it was rightfully received.
Thanks for the advice from a man that is named in a lawsuit
Oh,
in
here we
federal
go,
court.
here we go.
That's correct.
No,
I
and
know
that's
the
what-
way you
well,
got this
that's
law.
right.
It's public,
Is
no,
it,
it's
is it,
public
is it
knowledge.
possible for you to
It's
speak
public
without pointing?
knowledge.
Is it possible for you to speak without pointing?
It's public
No,
knowledge.
have a seat.
It's
Stop
public
making a
knowledge.
mess.
Have a seat.
Let's move on, let's move on.
All right, that's all. All right, so I've instructed for the record our borough attorney and administrators to notify the affected officers to make sure that they know that their information was improperly disclosed. Okay? And we will try to work that out with them. All right? I don't have anything else for the caucus unless anyone else does. We should just break now and go into the regular meeting.
Did everyone get the piece of paper that has your name on it and look at the tax bill that's at your desk? Lorraine?
No, but that's.
No, oh, okay.
Somebody emailed that.
Oh, okay, so
I found out a while ago.
just to make sure we realize if we have to recuse or not, pay attention to
I was
those.
gonna leave it to you anyway.
Oh, now I have to remember everything.
Okay, so I have a question though regarding the sheet.
Well, this is Caucus, you can ask your question on that.
Well, just because it says Sinai meeting and February 8th, the Sinai meeting I didn't vote.
Okay.
So February 8th I did, so which one relates to what for those 2 days?
There were only two that were voted on February 8th.
Okay, so 2
Did they have, did you want to?
Then I can't, don't I have to recuse myself to the other one?
What does that have?
That's a good question.
Well, if you, do you have
She
any
didn't vote
conflicts?
and sign nine, she wasn't sworn in yet.
Right, do you have any conflicts with the information in red as far as the owners?
No.
No.
All right, we'll give you an answer in a minute, okay? I want to put Catherine first on the earlier.
Do you have any conflicts with any? Okay. So there are no conflicts.
All right, Gloria, I asked Chris to come tonight to request.
Oh, about the question here.
Yes.
Yeah, he's here.
Yeah.
I'm sorry, we're still discussing business.
Folks, hold on, folks, if you have anything you want to discuss, please go outside, but Gloria, did you want to ask Chris something now?
Yeah, otherwise,
Yeah.
I don't want to...
Chris, so I just wanted to make sure that there's like 8 different tax appeals. I understand that, these settlements were discussed back in February and also at the Sinai meeting. I just want to make sure, it's a lot of money that we are giving back in credit. So we have 8 tax appeals. We're refunding $76,000. And we're refunding we're actually giving credit back to the property owners in the amount of $243,000 approximately. Just want to make sure that, these are the funds that we have in the budget, budgeted for.
Yeah, so all of the properties on the list were included in the tax appeal attorneys. All of the properties that are on the resolutions were included in the tax attorney's initial estimate of what the settlements were going to be. A couple of them did come in over what the estimates were. We included, for aggregation purposes, we included about $317,000 in estimated credits, not including refunds. And the refunds that we have in the budget are $147,938.50. So to date, we're well under that. There are still, on the list that he provided, there are still a couple of properties that we might still be getting judgments for. As of right now, we're on track, but like I said, a couple of them are over what the estimates were, so if others fall under, we'll be okay. It's actually less of a concern about the credits of the 240 or so that are on resolutions tonight. Not only, but 218,000 of that are credits for 2017. Some of them go over to 2018 as well. So that'll be helpful.
Actually,
Did you use the mic, Chloe?
Yeah, so the amount that we're giving back in credits for 2018 is about 150,000, but in 2017, it's, about 250. So I understand that, a lot of these tax refund settlements are in credits, but how is that really helping the borrower? Like, opposed to giving back in refund, because when you're giving the credit, right, you're taking less back from the property owner. So it's almost the same.
Yes and no. You have a little bit more control over it when it's a credit because it gets built into your reserve for uncollected taxes. So every year the borough is required to appropriate 100% of the taxes. We're going to have to collect that one way or another. So if our collection rate is 98%, we're required to appropriate the additional 2% to make sure we get that 100%. We still have to pay the schools, we still have to pay the counties, we still have to pay our obligations. So in the event that we have a better collection than in a previous year, we'll be ahead of the game. If we issue refunds, you have to have known that when we do the budget. If you don't know the exact amounts when we adopt the budget, then you're required, or you really don't have much of a choice but to do an emergency authorization. When you do emergency authorization, you're generally going to go after debt. You're going to be paying interest on the amount that you borrowed to pay those obligations. So it's better to do credits in some way. It's more work on our side because we have to keep track of the credits and apply them, year over year. But ultimately, for the taxpayer, it's really 6 and 1/2 in the other, depending on how much you can absorb without having to borrow money. Once you borrow money, then you get into the bond counsel and cost of issuance and interest on the debt.
Do you have any idea how much more tax settlements you receive coming?
Well, over the estimates, I think she means, right?
Right, for the rest of the year, 2017.
What's still out there, what's still pending?
Well, there's a couple of, so when we had gone over the budget process initially, we had asked the tax appeal attorney what properties he thinks are going to settle this year, because there are a lot that are pending in tax court that might be there for another couple of years. Yeah. So we really, we got an estimate. I imagine that he did the best that he could with getting us what he thought was going to settle. So, based on, you've got 8 tonight. There were another 6 on his list. I believe that maybe 1 or 2 of them might have had resolutions earlier in the year as well. So there were 14 total that he thought were going to settle tonight. Are there more that can possibly, get settled by the end of the year? Sure. But, for an entire list, we have to get back to the tax appeal attorney and see what else is out there pending.
So just to be on the same page, did you say we have about 147,000 because we're under right now?
The total that we budgeted for tax appeals is $147,938.50. The amount
of refunds. budgeted.
Yeah, that's in the budget document for refunds. The amount for tonight, which was actually already paid, is $76,221.36. That was a previous judgment. So there is, still, $70,000 in that budget line item. So.
Thank you.
Thank you very much. Appreciate you being here.
You know what, actually, can we talk about the capital funds? Because I know, is this a good time, Anne Marie, to ask Chris, because I know he's going to want to leave after this, right?
Yeah. And it's only 2 minutes till our regular meeting, so.
So, what I want to ask Chris before he leaves is that I know we're going to be discussing the bond ordinance with Jill later. I just want to make sure that we have sufficient funds in the capital improvement for the down payment, for the field, plus other, improvements in public properties.
So one of the first questions, and bond council's right on top of that, that is their first question as well. Do you have the funding available for this? We do. It's mixed between capital improvement fund. We had a larger capital improvement fund than previous year, anticipating additional ordinances. We also had some left over from last year that we hadn't used, or it could have carried over from previous years, but it was in the opening balance. And then we have additional, since this is a parks and recreation upgrade, we have additional trust fund money that we can use as part of that capital improvement fund to the tune of $2,000. The bond council wouldn't even draft an ordinance if we didn't have the capital money available.
I wouldn't have even asked them to draft it.
Yeah,
I just did that money.
Very diligent about that. Thank you. Have a motion to adjourn. So moved. Second. All in favor?